So this topic is an extension of duress. We have just looked at the defence of duress by threats, and this is the next part to that. So these are two defences, but they are on the same handout. Duress of circumstance, sometimes called duress by circumstance, and the separate defence of necessity. Now, different teachers, different academics deal with these defences differently. Some will treat them as the same, some treat these defences as two separate defences. A few notes to write at the top. In effect, when you look at the ingredients of both defences, there is very little difference between the two defences. So you look at the mechanics and the test involved in duress of circumstance, and then you look at what necessity requires, it's incredibly similar. And in fact, in some of the cases, the Court of Appeal have called the defence of duress by circumstance necessity by circumstance. So a lot of the judges have been confused or maybe deliberately combined these two defences. However, we have to acknowledge that these defences are not the same. Duress by circumstance was created in the 1980s, whereas necessity was created over 100 years ago. Also, secondly, they both have different titles that also makes them different. When you examine the test that applies to both, the tests come from different cases, so that's another difference. And also murder. You can plead necessity in terms of murder, but you cannot with duress by circumstance. So this leaves us in a difficult position, in that clearly these defences are not the same, however they are very, very similar. So the phrase to utilise, which we have used before in other areas of criminal law, is that these two defences are effectively the same, which in my language means they're sort of, almost the same, but not quite. Hence I've put them on the same handout, which many deal in that way as well. Okay, so in terms of the handout, we'll start out with necessity, which existed first, and then we'll move into the creation of duress by circumstance, and then move back to the re-emergence of necessity, and then analyse the situation today. Okay, so these defences, which we are treating as being effectively the same, arise where the defendant finds himself in circumstances so intimidating that he is forced to act and commit a crime. The threat doesn't come from a person, as in duress by threats, but it comes from the circumstance surrounding D. So nobody tells D you must do X or Y, because that would be duress by threats. This is the situation which forces D into committing a crime. So I think I gave you the example of a student laying in the middle of St Mark's Avenue outside college. And I can see that a car or a lorry is coming down St Mark's Avenue, which will then run over and plough into the student. I feel that it is necessary for me to intervene, and the circumstances are making it necessary for me to intervene to make sure that student does not die. So when I pick up that student and throw them across the road, that is possibly section 47 ABH or more. But of course, this is where the defence would come in. So the circumstance would have forced me into committing a criminal offence. Also, somewhere around the top or this section, if successful, this results in a full acquittal. So again, the test has to be pretty tight in terms of we don't want to acquit people committing serious crimes. They have to have a really justified reason for doing the crime under duress. Okay, so there is some debate, as I've mentioned above, as to whether these two defences are separate or whether or not it's just two different terms or names for the same defence. And actually, when you analyse the viewpoint of the judiciary, some of the judges perceive that these are the same defences, whereas other judges and academics have said no, they're separate. So in other words, it's one of those areas which definitely Parliament need to reform. So starting with the necessity defence then, so this was recognised over 100 years ago, whereas duress by circumstance only came about in the 1980s. But the common bottom line, is that both defences are concerned with threats of death or serious injury which overbear the will of the victim. So it's not verbal, but the circumstance has overborne the will of the victim, who then becomes the defendant. So necessity first of all, so going back, so I can remember this from studying law at Notre Dame, that my notes said that necessity was not a general defence at all in English law. So generally, necessity has not been accepted as a general defence under English law, as the defendant would be choosing to break the law and escape liability. Let me give you some examples. Let's say I stole, my car goes back to the loan company later this summer, so I stole a really nice Audi A4, let's say, and then I'm charged with theft. My defence would be I needed a car, so I would have a general defence. If you were caught stealing expensive food in an expensive supermarket because you were homeless, if necessity was defence, then that would be a full acquittal. You needed that food to save your life. If I had a student who never did their homework, produced U's on every single piece of work, I could say I killed that student. Why? Because I needed to, they weren't going to pass the course, etc, etc, etc. So Lord Denning justified that necessity should not be a defence on the grounds that, famous quote, if hunger was once allowed to be an excuse for stealing, it would open a door through which all kinds of lawlessness and disorder would pass. So that's sort of fancy convoluted words and phraseology from Lord Denning, basically saying once you were allowed to say you stole because you were hungry, then the floodgates would open. People would steal, commit assaults, commit murder, etc. And they would have a defence, a full acquittal, which clearly would not be justice or good public policy or any of that. So from day one, really, necessity has never ever been a general defence. So a few cases to establish and back that contention up. Kitson, very much one of the most strangest cases in English law. This was where a defendant was in a car with his friend. Now the defendant was drunk, but his friend was not drunk, but his friend was driving. So the sober man was driving the car. And the defendant, who was drunk, had fallen asleep in the back seat of the car. But when he awoke mid-journey, he awoke to find that the car was moving minus a driver. So Dee felt he had no option but to take control of the vehicle and just bring it to the side of the road and make the vehicle safe. And that's what he did. He claimed control of the vehicle in order to bring it safely to the side of the road, but then unfortunately was caught and convicted of drink driving. Okay, so just a note to add here. Necessity failed. Reasoning being, necessity is not a general defence. Never has been. If that defendant succeeded, albeit very genuine in his set of facts, everybody caught drink driving would say, I had to get to X or Y to save somebody, to do this, to do that. There would be a reason every time as to why they had to drink drive. So it suits, very much so, good public policy to say necessity is no general defence. Second case on necessity is the case of Bukkirk. This was a defendant driving a fire engine which passed a red light on an emergency dash call and then caused a collision just shortly after that. Again, the defendant raised necessity in that it was needed a and necessary to take place in order to get to the emergency in hand. However, necessity again failed. Again, just add the note why necessity is not a general defence. So some students get confused on that fire engines and police officers can just fly through lights and things like that. There is still a civil issue if they crash. That still is, they're breaching the civil law potentially, and that can lead to a civil action. Okay, Southwark, and that's London Borough Council and Williams. This was another necessity case. This was to do with homeless people. These were homeless people in London who were living on the streets, and their families, husbands, wives and babies and kids. And the council were pretty slow in terms of rehousing these people, so they were living on the street. And so they saw some empty houses, council houses, which were available but not officially available. So some of these homeless people took refuge and stayed illegally in the empty council houses. And this family in question raised the defence of necessity, which again failed. So just add the note again. Failed, one reason, necessity has never been a general defence. So we're picking up a picture here of all these cases, valid or invalid, worthy or not, that necessity is not a general defence. It would lead to mass abuse and criminality. And then probably the most controversial stroke well-renowned necessity case was the case of Dudley and Stevens. So these were two defendants, Dudley and Stevens, who were marooned, I suppose, shipwrecked 1,600 miles away from land on a little boat with very little food and, more importantly, a young cabin boy. After 20 days of no food, clearly you must be at that point very close to death. So after 20 days, the defendants made the decision to kill and eat the cabin boy. But very unfortunately, just afterwards they were rescued, and clearly at that point it was ascertained that they had killed the young cabin boy. So both Dudley and Stevens raised the defence of necessity for the offence of murder. Again, the defence failed as the defendants were convicted of murder. Reasoning: necessity is not a general defence. Now, the court added at the time that the sanctity of life is of the utmost importance. In other words, which is judicial reason, somebody's life is never more or less important than another life. So it's not within the defendant's remit to choose to kill somebody else to save their own skin. So necessity failed. Just as an aside issue, which is probably of interest, maybe not relevant for the exam, both defendants were convicted of murder, but the Queen at the time ordered a special verdict and a royal pardon. So in effect, they must have served very little time in custody. However, just to make one general point on that first side of the handout, I would possibly just put an arrow down the left-hand side. Kitson, Buckoak, Southwark and Williams, Dudley and Stevens all confirm one thing: necessity has never been a general defence, backed up by the comments of Lord Denning. So moving on then to the creation of the second defence, known as duress by circumstance or duress of circumstance. Neither is wrong or right, they're just different phrases that different people use. Okay, so we've just said on the first side of the handout that duress by necessity has never been a general defence. And then something very unusual and interesting happened and occurred in the 1980s, whereby the defence of necessity inadvertently, almost by accident, returned within the creation of a new defence, which was now labelled duress by circumstance. The case law since the 1980s has made it now impossible to deny the existence of some form of necessity. So, just to sort of paraphrase that in my own language, basically duress by circumstance started off in the 1980s, and some of the cases that were succeeding under this defence, clearly when you scratch below the surface and look at what has taken place in the judgment, are really cases of necessity. So in other words, it is easy to argue, or possible to argue, that the defence of necessity has returned in some respect, but with a new label, a new test, a new set of cases. So this put a huge question mark on, did necessity now exist? And if it does exist, is it now called duress by circumstance? So I think if we go through the case law, it might make more sense. So the first case in question is the case of R.V. Willer. Okay, so this was the first ever case of duress by circumstance. Okay, so in Willer, so this was a defendant, and he was driving down a narrow road in a precinct in a shopping centre or town centre when he was surrounded by a gang of threatening youths. So very scary for the defendant. In fact, when you read the law report, the defendants were surrounding the car shouting, "Kill Willer, kill Willer." Clearly they must have known him, but shouting, "Kill Willer, kill Willer." So surrounded his car, so he was very scared and frightened. So Willer drove very slowly onto the pavement in the precinct in order to escape, and went straight to the police station where he reported the matter that had happened. Instead, the police said, "You've just admitted to driving on the pavement and therefore you've just committed a road traffic offence." So he himself was charged with a road traffic offence instead. Okay, so the Court of Appeal, who heard the appeal, quashed the conviction, as the trial court should have considered whether D drove under duress. So let me just sort of put a bit more detail to that. The trial judge said duress cannot succeed, or probably more to the point, did not even consider duress, and you can clearly see why. The only defence that existed at that moment in time was duress by threats. That's the only thing that existed. Did anybody tell Mr. Willer to get on the pavement? Did anybody inform him to drive through the precinct? Of course they did not. Therefore, duress by threats was completely irrelevant. No other form of duress existed. So the trial judge was right to not even consider duress, because there was no evidence of duress. Nobody had told him to go on the pavement. But then the Court of Appeal, so this is really interesting, the Court of Appeal said that this is a form of duress. Now, what in fact they had done, and this always amazes me, it does every single year and has done since I studied this as a student, that what they did is by accident created duress by circumstance. They've given the defence of duress. It's clearly not duress by threats, but it's something to do with the circumstances that D has found himself within. So by accident, which is amazing, how do you do that? Create a brand new defence by accident. They inadvertently created duress by circumstance. Now, in the bullet below, here we are, in the bullet below, that the case created, or is known now for creating duress by circumstance, brackets, did not name it. Why? Because they did not know they'd done what they did. They had no idea they'd created a new defence, which is amazing really. How do you create law and not even know that that's taken place? So they created duress by circumstance, and strictly speaking, that is per incurium. That is a decision, those of you that are doing sources or remember your sources studies from last year, A decision that's made in error can be ruled per incurium. Clearly, this is definitely a case which was made per incurium. Duress did not extend to a circumstance completely made in error. However, the Court of Appeal thereafter did not rule it so, but later said, yes, we like it, we will adopt it, we'll give it a name, we'll set a test, etc., which is what happened in the next few cases. So Willer, at the side, just let's make this a bit clear, created, you could put DOC, duress of, or duress by circumstance, or created circ, whichever. Right, so the next case, which wasn't too long after that, was the case of R.V. Conway. So the defendant and his friend were followed by an unmarked police car. Now, so obviously it didn't look like a police car and they weren't sure who these people were behind. Now, the friend had been shot in a very similar incident a couple of weeks before. So they both pretty much thought that this was a second repetition of the first event and that somebody may well be shot. So the friend ordered the defendant, Conway, to drive off fast, which he did. And then the police obviously made arrest. So the trial court, again, just to add some judicial reasoning, convicted the defendant. So it went on appeal to the Court of Appeal. The Court of Appeal quashed the conviction. What the Court of Appeal did is picked up what they had inadvertently, accidentally created in Willer and applied it to the facts and did two things. Number one, named the defence. So said that the duress defence now existed called duress by circumstance, which applicable to D led to a full acquittal. But also this extended the defence. In Willer, he was protecting himself. In Conway, he's protecting the friend, the passenger in the car. So this case did two things really. Number one, it adopted and named duress by circumstance. And secondly, it extended the defence in that it could be that D was protecting himself or another person closely related or responsible to him. Okay, so at the left-hand side, really, Conway, key issue there is named it, extended it. So within the case of Conway, the leading judge, Lord Justice Wolfe, made some comments about the defence. And this is really interesting to me because it tells me the viewpoint of the judiciary. And what Lord Wolfe said is that duress of circumstance is an example of necessity, and whichever name is utilised doesn't matter. So what he's saying there is duress by circumstance is the same as necessity, so whichever label you use doesn't matter. Ouch. Not sure how to quite interpret that, but it's showing confusion over circumstance and necessity. It's also showing that the judge this time thinks they are the same thing. It also shows that necessity now is a defence, which it hasn't been a defence for hundreds of years. So it throws up a massive question mark that duress by circumstance does exist and it possibly is a necessity with a different name. Really, really confusing, yeah. Okay, we'll come back to Lord Wolfe. Right, the next case of circumstance was the case of Pamel. So this was a defendant and a friend had come round in the early hours, so it's after midnight, and his friend came round and showed him this brand new gun that he'd purchased. And he was showing Pamel this gun, and he threatened that he was going to utilise this gun to shoot a rival gang member. So Pamel, as the upstanding citizen that he suggested he was, confiscated the gun and sent his friend on his way. And then the police, for really random reasons, searched his house. So there was a raid on his house and they found him in bed with the gun, which was just next to his bed. Okay, so again the trial judge convicted So this is all about what happened on appeal. And on appeal, the conviction was quashed, as duress by circumstance should have been left to the jury. So in effect, the trial judge had refused to leave it to the jury because the trial judge deemed it so that the reasonable man would have taken the gun to the police straight away. But thinking about that, that's for the jury to decide whether or not, and we'll come to the test in a minute in the next case, but whether or not it was reasonable to take the gun back immediately or reasonable to take the gun back in the morning, which is part 2 of the test, is for the jury to decide. Surely if a lot of police stations now close, early or 10 o'clock at night, so was it even practical to take a gun back at that time? So, anyway, ultimately, the Court of Appeal said duress by circumstance should have gone to the jury for them to consider. Now, this case was rather significant as well. We've got Willer that created the defence. We've got Conway that named it. This case extended it beyond driving offences. Both Willett and Conway were driving offences, so really the defence only applied to those. This case gave it general application to now gun crime, so extended it to all crimes, apart from murder, which we'll come on to on the last sheet. So at the side, just to make the significance of this case clear, Purmell extended the defence to all crime bar murder. Now again, bear in mind what we just said about Lord Wolfe above. The Court of Appeal, within the judgment, referred to circumstance and necessity interchangeably. So you've got one sentence, they're talking about duress by circumstance, then rephrasing that as necessity, circumstance, necessity. So actually, again, this is corroborating Lord Wolfe's judgment. Obiter comments above in Conway, which is actually at this point pretty much necessity. Yes, it does now exist, and it has just a new name, and you can call it one of two. So again, a bit confusing, but certainly the judges are saying that necessity has returned and within this new label. Okay, actually, but then there is a real problem with this decision. This case actually was a case of pure necessity. Now think about it, I'll just explain the difference there. Duress by threats, which we've done, you've got no choice. Fight or flight, you've got to get involved. You've been threatened, you've got to do it, you've been verbally told to do X or Y. With the cases of Willett and Conway, again, similar concept. Conway did not have a choice. He is surrounded by threatening youth. He's got to do something. No choice. In Purmell, there's a car. It's behind them. It's fast. It looks like it's a gunman. He's got no choice. He has to intervene. Whereas in Purmell, he did not have to confiscate the gun. What he could have done is to say, that's a very nice gun. Okay, thank you very much, and I'm going to bed. I don't have to see you again. Or then later report it to the police. There was no way in the world that Purmell had to confiscate the gun. And therefore there is a key difference there. Well, I had to act. Same in Conway, same in duress by threats. Purmell was choosing to get involved. When you choose to get involved, that's necessity as we knew it. The separate defence where you're choosing to get involved. So this was really confusing really, because this showed us necessity does now exist, but it has got this new label, new defence, new title, etc. But clearly there is a need for Parliament to reform, because this is very different to Wooler and Conway. Okay, so the next case then, Martin. Another Martin. So this is where the defendant, he drove his son to work. He'd been disqualified from driving, but he did drive his son to work, and the reason was he was late for work, but his wife, who had a very severe history of mental illness, had threatened to kill herself unless the son was driven to work. So he felt that he had no choice, that he had to intervene because she was banging her head against the wall. She was shouting all sorts of different threats, and it was clear with her mental background that she could actually go through with that and kill herself. So he did what he did, and he drove the son to work and was caught driving whilst disqualified. On appeal, Court of Appeal allowed the defence of duress by circumstance. So, this case confirmed that the Graham test was the right test to apply for duress by circumstance. So actually, when you think about that, if it's confirming the Graham test, then in fact this is the same as duress by threats. Apart from one's verbal, one's the events that bring about the duress. Actually, this is saying it's the very same defence. So at the left hand side, we've got Wooler created the defence, Conway named the defence, Permel extended it to all crime, bar murder, significance of Martin, it confirmed and set the test. So we've got a case by case development. So confirmed the Graham test, and also it was noted that necessity caused by an objective danger can equal duress by circumstance. So again, the courts are really confusing these two defences, pretty much suggesting that necessity does exist, but it is this new label of duress by circumstance. Now after that, it's not on the handout because it's on the threats handout. It was used in two or three other cases, but one just to note there, it was used again after the Martin case in Abdul Hussein. That was the hijacking case from Africa. I know it's on the threats handout, and that's because it's a timing case, and these two are now brother and sister defences. And of course, duress by circumstance succeeded. Okay, so moving on to the next part is the re-emergence of the actual singular separate defence of necessity. Okay, so far, just to recap, that so far it was clear up till the 1980s that necessity did not exist at all. Then during the 1980s and thereafter, it became clear that necessity may well exist, and if it does exist, it's part of this new label, new defence of duress by circumstance. Then something very interesting happened in the year of 2000. The re-emergence of necessity as a separate individual defence occurred, which totally put in question everything I've just said on the last side of the handout. So the defence of necessity experienced explicit recognition in recent years in its own right, totally separate from circumstance. And the key case which brought this to light was the case of Rie, which we've seen before. So in the case of Rie, it was in August 2000. Well, we know the facts because we've gone over the facts before, so just to recap very briefly, baby twin girls were born, but they were conjoined completely at the body, at the abdomen. But when they looked at the scans, it was evident that there was only one set of working organs between the two babies. So it was confirmed that within weeks, I think it was 6 to 8 weeks, if the babies were left as they were, then both would die because the pressure on one body was just too much. However, the doctors wanted to separate the children, which would in effect kill child B to save child A. Now, of course, if the doctors did that, that is technically murder. And the parents who were religious and had a religious belief, they did not want the doctors to do that. They wanted to let God's will be the way. And if God created them as a joint human being, and that was his will and his way, etc. So they had to take it to the Court of Appeal to ask for permission in order to perform the operation. And so it was held. Necessity could be available for the doctors if they were charged with murder. So that gave the doctors permission to proceed with the operation and separate the children. Now, when you actually look at the mechanics and facts of this case is what we would call a case of pure necessity. Now, a case of pure necessity is a case where it can never be duress by circumstance. It's the exception to the rule. 90% of duress by circ cases can also be necessity, interchangeable between the two. Then there are one or two cases which are very rare and usually once in every 10-20 years where the facts of the case suggest it's the exception to the rule and it is what we call pure necessity, just necessity on its own. So this was very much so a case of pure necessity. The evil, number one, was not directed at D. D chose to intervene. So there was no way that the evil, so the doctors, in other words, they didn't have to do anything. These babies were from Malta. These babies came to Manchester just because we had the technology to deliver the babies. And all the doctors had to do is say, yeah, fair enough, you're born, now you go back to Malta. So the doctors, by taking this huge appeal, did not have to do anything, so they were purely choosing to intervene. Remember, with duress by circumstance, that is not the case. You've got to act. Willa Conway, you've got to act because something will happen. Secondly, duress by threats and circumstance can never ever be available to murder. Well, this was available to murder, and that's another second key characteristic of necessity. And thirdly, the threat this time was from an internal source. You think about all the circumstance and threat cases. The threat is always external, it has to be. So in duress by threats, it's somebody externally threatening you to commit a crime. With Willa, it was an external threat. The youths and the guys in the gang surrounding the car, that was external. Conway, it was the unmarked police car outside the car. That is an external threat. So each time you're looking at threats or circumstance, the threat has to be external. This time the threat was inside those two baby girls. So when you look at that, the evil was not D. He chose to intervene. It was available for murder and the threat was from an internal source. We're building up a picture here of circumstances, that's a bad phrase to use, but of characteristics which could never apply to duress by circumstance. This was the first time that we realised that necessity did exist, but it was not the same as circumstance. So it's all really confusing because it's case by case by case. Does it exist? And if it exists, is it the same as circumstance? This case is suggesting no. So it's putting a huge question mark over all of the circumstance cases and certainly the comments from Lord Wolfe. Now, Lord Chief Justice Brooke held that in cases of pure necessity, the actor's will is not overborne by external pressures. The defendant is choosing to intervene. Brooke summarised the requirements of the defence. So what we've got here is Lord Justice Brooke, in effect, setting out the test for necessity, pure necessity. So again, this tells us actually necessity is different. It has to be different. They've re-emerged the name of the defence and also reset the test. So it has to be different. So Brooke summarised the test as follows. Now what we're going to do is, because it's a bit wordy, and this was special study for a few years, what we'll do is paraphrase it, and through my experience with the exam boards, it's fine, students do really, really well by paraphrasing the test. It just makes it more accessible and easy to explain. Okay, so part one, the act that D has committed, the act must be done in order to avoid an inevitable and irreparable evil. Number two, no more should be done than is reasonably necessary for the purpose to be achieved. Number 3, the evil inflicted must not be disproportionate to the evil to be avoided. Right, so really let's paraphrase this and make this a bit more simplified because it's, like I say, a bit wordy. Part 1, let's paraphrase part 1. So the evil must be done, or the act must be done, in order to avoid an inevitable and irreparable evil. Sort of reconstructing the words there, D has to do an act in order to prevent GE, greater evil. So that's the way I've got students to do it for the last few number of years. Part 1, did D act to prevent a greater evil? So at the left hand side, just put greater evil. Right, okay, so part 2 and part 3, let's combine these together. So no more should be done than is reasonably necessary, and the evil inflicted must not be disproportionate. To sort of paraphrase and summarise those and combine those together, these actions must be reasonable and proportionate. So at the left hand side, reasonable and proportionate. Now, since this case, the case of Shayla, which is just on the next sheet, a fourth, or the way we've paraphrased it, the third, an extra requirement has been added to the test. So if you want to have that below number 3, or at the left hand side, it doesn't matter which way you do it, is that the defendant has to be able to identify the victim he is protecting. So just to summarise that, number 1, greater evil. D must act in order to prevent a greater evil. Number 2, for us, it has to be his actions are deemed reasonable and proportionate. Number 3, he has to be able to identify whom he is saving, either himself or somebody else, that he is reasonably responsible for. Now, when we run through this once in class, we'll draw this up on a huge table on the board. But actually, what does that tell us when you examine the test that we've just gone through there? This necessity defence, which has now been separated, is the same as duress by threats and the same as duress by circumstance. So the judges have gone absolutely overboard in detail and absolutely made it very confused and convoluted. So just to show you that, and again we'll pick this up in class, D must act in order to prevent a greater evil. What is D preventing in duress by threats or circumstance? Death or serious injury. Yeah, Graham test, D must prevent or act in order to prevent a threat of death or serious injury which he reasonably believed was there. So in short, we know that part 1 of duress by threats and circumstance is death or serious injury. Greater evil, death or serious injury. You could argue that potentially property could be a greater evil, but there is not one single case ever of property being a reason to justify necessity, so that's irrelevant really. Secondly, D's actions must be reasonable and proportionate. Part 2 of Graham is that a sober man of reasonable firmness must have acted in the same way. So I would ask the question, what is the difference? The reasonable man must act in the same way, or the actions must be reasonable and proportionate? For me, there is absolutely no difference. Apart from the wording, the paraphrasing, it's exactly the same. Now, the additional element added by Shayla, D must be able to identify the victim. That's exactly what you have to do with duress by threats and circumstance. You have to specify whom you are reasonably responsible for, whom you are saving, identification of the victim. So actually, the whole thing is an absolute state of ridiculousness because they are the same. Duress by threats is the same test as circumstance, and necessity, which now seemingly exists, the test is commensurate to that. So actually Parliament could easily just reform and call this one defence, one simple word, duress. Right, so question, how does this definition potentially differ from the definition of duress by circumstance? So we know that we've duress by circumstance because they utilised the Graham test. It has to be a threat of death or serious injury. Potentially greater evil could be wider, but as I just mentioned above, never has done. It could include property, but it never has done, so it's unlikely to do so. And the second difference really is the timing. With duress by circumstance and necessity, duress by threats and circumstance, we know the timing is governed by Hassan. So for circumstance and threat, the test today is immediacy. Immediacy, the threat has to be considered immediate or almost with no possibility of evasive action. So just to make that clear, duress by threats, duress by circ, immediacy, or almost. Whereas with necessity, you are choosing to get involved. So if you're choosing to get involved, there is no timing constraints at all. Think about in Re A. There was no time limit set on it. They didn't even need to get involved. They chose to get involved. So timing is clearly not immediate, and clearly there is no test at all. So suddenly we're realising there is a difference between pure necessity and duress by circ. Right, so Re A you could put down as a one-off error per incurium. However, certainly not, because it was used straight after in the next case called Re F. Okay, so necessity was again used and recognised in the case of Re F. Okay, this was a civil case, as was Re A, incidentally. And this was a girl who had a severe mental handicap, who had made relations or friendships with another boy who also had a handicap. And the staff at the day centre where they met realised that this friendship could develop further and could develop into a situation which would harm her physical and mental health. The doctors were of the opinion that if she did become pregnant, that would not be helpful or healthy for her mental and physical well-being. So the doctors wanted to actively sterilise, in her own interest, sterilise the young girl. So they had to obviously take that to the court to get permission. And the doctors claimed necessity and said this is a necessary intervention, medical intervention that needs to take place, and it was held that necessity could succeed. Now, the fact that the court have awarded necessity shows us that it must exist. They've named it, they've applied it. On the back of Re A, it's showing that necessity does exist and it is separate to duress by circumstance. So that was the second case. And then again, so closely afterwards, the case of Shayla. Necessity was again given explicit independent recognition that it exists as a separate defence. So this was a very famous case. It was on the news, and I got news for you, and all sorts of things. It was very famous at the time. David Shayla was a member of MI5, so part of the security services, and he was charged with writing and publicising articles in a book which disclosed official secrets. Now, what he claimed was he'd left MI5 because he believed lots of things weren't being done right. There were lots of unsafe practices, and he thought that because they weren't working to the level that they should be, that there would be some national disaster, some terrorist or public disaster. So he claimed he needed, brackets necessity, he needed to write this article and write this book to disclose all the issues, to therefore improve the service. So he fled to France, and I always remember watching the news. He came off the boat at France, and the police were waiting there to arrest him, which they did. And he was charged with breaching the Official Secrets Act. He raised necessity, saying that he needed to do what he did and write the book and publish and breach the official secrets in order to save the country, save the public. So he raised necessity. Now, on this occasion, necessity failed. So Court of Appeal held that necessity had to fail, and then they added the third requirement to the test. So was he doing what he did to prevent greater evil? Yes. Writing a book versus a national bombing or disaster? Yes, he acted to prevent a greater evil. Number 2, were his actions reasonable and proportionate? Yes. Writing an article, a book, it was a book and it was publicised in the, I think it was the Daily Mail. Yes, that was reasonable and proportionate to the event of some national disaster or terrorist act. So the Court of Appeal added an extra requirement: identification of the victim. Could he prove who he was saving? And the answer to that is the reason it failed. No, he could not. If he had some tangible detail or evidence of a bombing in June in a location or some kind of detail, then he could identify the type of victim that he was aiming to protect. But the fact is, it was pure speculation. He didn't know what would happen, if it would happen, and any kind of specific or even vague detail, I suppose. So necessity failed as he could not ID his victim or type. But actually, the bigger picture with Shayla, it's identified necessity exists. So read A, read F, Shayla all show one thing, that necessity does exist as a separate, individual, isolated defence. Now, Lord Wolfe, who we've just seen before on the first or second side, Lord Wolfe, again, was the main judge in the Court of Appeal, concluded that duress by circumstance and necessity are one and the same defence. My answer to that would be absolutely they are not. Separate labels, separate tests, 100 years apart, different characteristics between the two. One can be raised for murder, one can't, etc, etc, etc. So this is where it becomes confused and indicates the need for reform. So he concluded that both are the same. However, there will be exceptions whereby only necessity may be used, and they're the exception to the rule, pure necessity. That bit I get, that makes sense. What Wolfe is saying is whether you call most cases circumstance or necessity, don't matter, does not matter at all. They're one and the same. So take Willer, for example, kill Willer, the gangs around the car. Yes, duress by circumstance, he was forced to act due to the circumstance, but also he needed to do what he did. He had to intervene to prevent some sort of assault or worse. But the exception to the rule are pure cases of necessity. These are the individual, exceptional, once in a blue moon cases where they have to be called necessity only. Examples: read A, read F, etc. Makes sense. So back to my percentage world, what that is suggesting is 90% of cases, necessity circumstance, doesn't matter what you call them, what you use, it's the same thing, possibly using the circumstance test, i.e. Graham, but where it's pure necessity, read A, read F, it has to be that separate name, separate test. And you might see one or two of those in 100 years. So, pure necessity then, let's categorise it. I think we've touched on it a fair bit there, but let's just get a formal list. So pure necessity, which is the cases where they can never be called anything else but necessity, where D is not responsible V. So we know with circumstance and threats, you've got to have this link. Whereas with necessity, the mechanics usually suggest that D has got nothing to do with V. So the doctors in Re F, the doctors in Re A, nothing to do with V at all, could just have left it as it was. So that would suggest it's this pure necessity category. For pure necessity, also the threat can be internal, not external. With circumstance and threats, it has to be external. Think about it, with duress by threats, the threats are coming from some person externally. With duress by circumstance, again, it's a car, it's the gang surrounding the car, it's got to be something external. In both Re A, Re F, the threat was internal, inside the girl and inside the two babies. Where the defence is needed for murder, the next sheet, it's a single-sided sheet, which is about the limitations of duress, meaning all three defences. The main limitation is it can never be used for murder, attempted murder, or secondary participation in murder. Pure necessity, it can be used for murder, Re A. And another example of pure necessity and linking to that point of murder was the World Trade Center, which was the Twin Towers disaster back a few years ago. And this is something I remember very clearly. I think you may not remember it in detail, but the World Trade Center, which is where the Twin Towers were blown into by the several aeroplanes. Now, what actually happened, the first plane flew through one of the towers, and the second one then flew through the second one, just crashing through the building. But then the whole buildings, or both buildings, started to set alight. There was huge massive fires, and then it brought about collapse. So only from being to New York, just after the Twin Towers incident, some of the tallest buildings there are just absolutely miles high. The Twin Towers was double the highest that I saw, so incredibly high buildings with hundreds of levels and floors. Now, what in fact happened is, and this is reality, because the lifts had shut down, that people had to, with all this dust and fire, run down hundreds and hundreds of flights of stairs. Plus, with the panic and the fear, what happened was, in some of the stairwells, some of the victims just froze and completely blocked the stairwell to everybody else. So you've got minutes to live. There's fire, there's smoke, the building's collapsing, another plane could arrive. You've just got absolutely no time to think. These people were coaxed, people tried to help them to go down to the bottom of the stairwell, and eventually they were just kicked down the stairway. Now, if you think about that, I mean, clearly those people were never charged because it was such a big disaster. But if that had led to the intervention of the courts and the police, that is definitely what we would say is a case of pure necessity, where D was not responsible for V but choosing to intervene. Threat wasn't internal, so that bit doesn't apply, but all bits don't. Each of these are separate characteristics which can indicate pure necessity, but where the defence was needed for murder, so that would trigger part 1 and bullet 3. It's just an example of a case of pure necessity. You could never use duress by circumstance for that, but you could use pure necessity had they been charged. So again, that would be distinguishing Dudley and Stevens, the cabin boy, and the sailors, which said necessity didn't exist, and it certainly didn't exist for murder. Suddenly here we are saying yes it does, and yes it can. Another example, which this was, I think it was the 30-year anniversary last 2 weeks, the Zeebrugge ferry disaster. So this was a roll-on, roll-off ferry, which people go on to places like Amsterdam and Zeebrugge. They'd left the massive iron, raw iron doors open. So it's all about speed and making lots of money. So they left the bow doors open and they set off sailing, and it was rather choppy conditions, and the water got into the vessel and capsized, and lots of people died. I can't remember off the top of my head, but it was well over 100 people, I think. But lots and lots of people died. the whole thing capsized in seconds. It was terrible. Now, when the ferry was capsizing, and if you've ever seen a ferry, they're hundreds of meters high. When it was capsizing, people had literally minutes to crawl down. It was freezing. It was like this time of year, so it was sub-zero temperatures, and the people that were trying to escape had to climb down rope ladders down a huge, massive vessel, which is like flights high. There were elderly, there were kids, there were people who were just plain scared. So again, these people were absolutely scared and in fear, and some of them completely froze. But they were blocking the exit and the chance to live of many people on the ferry. So again, what happened, similar to the World Trade Centre, is people eventually, after trying to coax and help these people, is kick them off the rope ladder, killing them, but of course then allowing people to survive. Had they been charged, and the CPS in the UK chose not to, had they been charged, that had all the hallmarks of a classic case of pure necessity, where D was choosing to intervene, and also, probably more to the point, where D needed the defence for murder. Right, okay, so bringing this back together then, so ultimately, there still remain some differences between the two defences of duress by circumstance and necessity, and also a difference between duress by threats and circumstance. So really where the law is, before we get to the last two cases, the law is pretty much in a state of inconsistent and confusing mess. Duress by threats, we know, as the same test, Graham, as circumstance. Duress by circumstance is possibly the same as necessity, yet these recent cases explain these separate, distinct cases of pure necessity. So it's not really clear. Have we got three defences, two defences, or one? Have we got three different tests, or is it all really Graham? And it's just Parliament needs to reform. So ultimately there still remains some differences. So duress by threats and circumstance cannot be raised for murder. Add necessity can. So there's clearly a difference there. Circ and threats can never ever be raised for murder or ought to do with murder, where necessity can. So it's a clear difference, saying they are separate. Duress can only be raised where D reasonably believes there is a risk of death or serious injury to him or someone else who is deemed reasonably responsible for. We know with necessity, D can choose to intervene, re A, re F. The doctors just decided they wanted to intervene, they didn't have to, but they chose to intervene. So that's a clear difference between necessity and the other two. Academics describe duress as an excuse. So that is after you've done the crime, after you've committed the act, you're using it as an excuse. So I think Wooler and Conway, one spared, one went onto the path in the precinct. Afterwards they said, "Ooh, duress, I had to do it. I was forced onto the path or forced to speed." Whereas with necessity, it's a justification before you even do the crime. Re A, re F. Both doctors in both cases chose to seek permission before they even committed the potential crime. And timing is completely different between circ and threats. And necessity, there is no timing with necessity at all because you're choosing to get involved, but then you've got the immediacy test from Hassan for circumstance and threats. And then the final thing just to add there, the internal issues can only ever be necessity. For circ and threats, it's always external, or always has to be external. So there are still some key differences, the name, the test, and the things we've just cited above. Okay, so at this point, we were pretty confident that threats definitely exist, circumstance definitely exists. It's probably interchangeable and you can use it with necessity or not, but the exception to the rule is where it's pure necessity, re-A, re-F, has to just be the N word, necessity. And then the last two cases just put a huge question mark over the lot. So, the Court of Appeal have reaffirmed that necessity as a general defence does not exist in the last two cases. Wow. So you've got Quayle, which was 2005, and then Altham, which is 2006. Both very similar cases and both sort of arguing the same point. So in Quayle, both drugs cases, Quayle, it was a defendant who used drugs. It was cannabis, both were cannabis. And they were using the cannabis but for a medicinal purpose, for the relief of MS. Now, I'm not going to get into the logistics and whether this is right or wrong, because I am certainly not a doctor, but there was a case this week, indeed in the news, about this, where, think about it, things like opium and a lot of the drugs used for cancers, which are cocaine related. So here we've got this argument that this drug, cannabis, could be used to help certain conditions. I have no idea whether that's right or wrong, because I am not a medic and I don't wish to get into that argument, but that's what these cases were in relation to. So in Quayle, he'd used cannabis for the relief of his condition MS. So he tried to raise the defence of necessity, saying that I needed to do it. I've tried every drug going from the doctor, every form of support that I could get from the medical world, and this is the only thing that worked. Then in 2006, so this is pretty much the year after, Altham, the defendant had been in a really bad road accident, and as a result he had these really, really, really bad severe leg injuries and was in constant severe pain. He'd used drugs from the doctor, acupuncture, antidepressants. He'd used everything that was available to him to try and work, and nothing had worked. And then when he tried cannabis, doing some research, that worked. And so again, he was charged with a drugs-related offence. In both cases, the Court of Appeal, same men that decided a lot of the cases above, said no defence because necessity is not a general defence. Wow. We've just gone from the starter page of the handout saying it does not exist, then saying actually it might exist, it's part of circumstance, then moving to yes, it does exist as well and it's separate. And these last two cases state that it's not even a defence at all. If this is not an argument for Parliament need to reform, I don't know what is. Unbelievable. Now, so as a result of these two cases, it is very unclear and uncertain whether necessity is a general defence, but the courts have continued to use the two phrases, two defences, interchangeably, and some judges still believe they're one and the same. In conclusion, Parliament need to reform. So ultimately, where do we conclude on this one? We could say option number one is that necessity doesn't exist. I don't believe that at all. I do not believe that at all. Necessity, re A, re F, Shayla, there's a test. It clearly does exist in some respect today. Option number two, which is what I buy into, is it does exist, just nothing to do with drugs. And that seems absolutely brilliant public policy. If you allow these two defendants to grow or use, in the case that would be both, grow and use drugs, then can you imagine how many drug dealers would say, I had to do it because X or Y? How many drug users would say, I had to do it because it was necessary? So in short, I think basically Quayle and Altham are drugs. And drugs, you can never argue it's a necessity just because of pure public policy. So, in effect, my conclusion would be circumstance and necessity are the same. You can use the terms interchangeably, preferably the new phraseology, which is duress by circ. The only time you need to use the necessity phrase and test is where it's pure necessity, which is really, really rare, read F. Okay? Quayle and Altham we could probably justify in that they were both drugs cases, which drugs is a political football and no judge is ever going to say that's part of any defence. But your final comment on the sheet is that there is no better case for saying and arguing Parliament need to reform.